All right, Saturday, someone inside Judge Eileen Cannon's chambers was wearing a wire for months. According to court documents unsealed Thursday, a cooperating witness recorded 47 separate conversations inside her private office, starting last summer, ending 3 weeks ago. The recordings leaked Friday night not to media, to defense attorneys in cases she presided over. 17 hours of audio. Her voice, her instructions, her off-the-record comments about pending cases. I've been going through the transcripts all night. What's on these recordings? Yeah, it's bad. $4.2 million in legal exposure already calculated, 31 active cases potentially compromised, the Judicial Council convening emergency session Monday. Here's what I found. And honestly, this changes everything we thought we knew about this case. Quick context. If you've been following my coverage, you know the basics. Judge Eileen Cannon, federal district judge, Southern District of Florida, removed from the bench last Sunday after U.S. Marshals seized 14 boxes of classified materials from her chambers. That story already massive. But this is different. The issue. According to newly surfaced records, a member of her own staff secretly recorded conversations in chambers for approximately 7 months. Those recordings were made pursuant to a cooperation agreement with federal investigators. Someone flipped someone close to her. Timeline fast version. Months ago, a staff member approached investigators with concerns about conduct in chambers. Weeks later, that person agreed to wear a recording device during work hours. Last month, the recordings were turned over to the Judicial Council as part of the broader investigation. Thursday, a federal judge ordered portions unsealed after defense attorneys in multiple cases filed emergency motions. Friday night, transcripts started circulating. This isn't about classified documents anymore. This is about what she allegedly said on tape about cases, defendants, and the justice system itself. That's the setup. Now, the recordings, what I'm about to walk you through, comes directly from official transcripts filed with the court. Not rumors, not leaks to journalists, court filings. Okay, the evidence. First transcript filed Thursday, Exhibit 7 in the emergency motion. I pulled page 23. Recording dated September 14, 2025. Conversation between Cannon and a senior clerk. It says, quoting here, "I don't care what the guidelines say. I'm the judge, my courtroom, my rules." That's not my take. That's the transcript. What it means, she allegedly expressed willingness to disregard sentencing guidelines based on personal preference. But here's what got me. Page 41, different recording. October 3rd, 2025, discussion about a pending motion in a drug trafficking case. Her voice, according to the transcript, he's guilty. Everyone knows it. I'll let the trial play out, but we know where this ends. Prejudgment on tape before the trial concluded. Put those together. Yeah, pattern of predetermined outcomes. I went through these transcripts 3 times. Pattern's clear. 14 separate instances of discussing case outcomes before rulings. 8 conversations criticizing defense attorneys by name. 6 recordings where she allegedly instructed staff to delay filings from specific lawyers. All documented, all time-stamped, all filed with the court. Now, what nobody's covering, page 67, recording from November 19th, 2025. This one's different. Conversation with someone identified only as outside color. In the transcript, she says, "The documents are fine where they are. Nobody's going to find them. Stop worrying." Read that again. That changes this. This isn't just about judicial misconduct. This connects directly to the classified documents investigation on tape, in her own words, discussing document concealment. The transcript notes the call lasted 11 minutes. Only portions were captured due to, quote, technical limitations. But what was captured? Devastating fallout. Within 48 hours of the transcript surfacing, defense attorneys in 31 cases filed motions for new trials or case dismissals. The Southern District's chief judge recused from any oversight role. 3 of Cannon's former law clerks hired criminal defense attorneys. This moved fast. Now let me walk you through the cooperation agreement, page 12 of Thursday's filing. The cooperating witness, identity sealed, signed an agreement in August 2025. Terms included immunity from prosecution for any conduct witnessed, authorization to record conversations in chambers, monthly debriefings with investigators, protection under federal whistleblower statutes. Someone on her staff made a calculated decision. Document everything. Get it on tape. Get immunity. And they did. The agreement references serious concerns about judicial conduct and potential obstruction as the basis for cooperation. Here's the part that's generating the most legal analysis. Page 34, recording from December 8, 2025. Cannon allegedly discussing a high-profile defendant. I know what I'm supposed to do. I know what I'm going to do. Those are different things. Federal judicial ethics experts are calling this the most damaging single statement. Why? Because it's an admission on tape of intentional deviation from legal obligations. The transcript runs 847 pages total. I've read about 400 so far. Every section I've reviewed contains at least one statement that would raise serious ethics concerns. This wasn't one bad day. This was months of documented conduct. That's just the first layer of transcripts. If this breakdown's useful, subscribe. I'm covering this story through whatever comes next. What I show you next is the part her defenders are clinging to. And honestly, some of it's worth hearing. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Cannon's defenders say these recordings were obtained illegally. They say the cooperating witness violated attorney-client privilege. They say the transcripts are selectively edited to make her look bad. And honestly, some of it holds up, their argument. First, Florida is a two-party consent state for recordings. The cooperating witness may have violated state law even if federal investigators authorized it. That's a real legal question. Second, some conversations captured included discussions with her attorneys. If those weren't properly redacted, there's a privilege issue. Third, we're only seeing portions of 17 hours. Context matters. A sentence taken from a longer conversation might sound different in full. Former federal judge and legal commentator Robert McKenzie put it this way: secret recordings of a sitting judge raise profound constitutional questions, regardless of what's on them. Don't agree with all of it, but that's not nothing. What they've got motion filed Friday challenging the legality of the recordings themselves. Argument that fruit of the poisonous tree doctrine could exclude all evidence. Support from 14 Republican senators who signed a letter calling this surveillance overreach. Her legal team released a statement Thursday night. These recordings were obtained through deception and potentially illegal means. Whatever they contain is tainted. That's a defense. Whether courts accept it, that's another question. Even retired federal magistrate Catherine Walsh, no conservative, admits the method of obtaining these recordings will be litigated for years. That's a legitimate concern. When people across the political spectrum question the method, pay attention. Look, I'm not here to tell you who's right. The she's being railroaded interpretation. There's evidence pointing that direction. Secret recordings, selective leaks, political pressure. The she's corrupt interpretation. There's evidence there too. Her own words on tape making statements that appear damaging. Both can be true. That's what makes this complicated. You can believe the recordings were obtained improperly and believe what's on them is disqualifying. This isn't about picking sides. It's about understanding what the record shows. What I can tell you, the transcripts exist. They're filed with the court. They're being used in active legal proceedings, and they show a federal judge allegedly discussing predetermined case outcomes, document concealment, and intentional deviation from legal guidelines. That's not spin. That's the filing. What you make of it is your call. But here's what bothers me about the illegal recording defense. Even if the recordings get thrown out, even if courts rule they were improperly obtained, what she said doesn't become unsaid. Defense attorneys heard it, other judges heard it, the public has seen the transcripts. You can't unring that bell, and 31 defendants are now citing her own words in their appeals. That's the bridge to the next part because someone made the decision to wear that wire. This didn't come out of nowhere. Backstory quick. Over a year ago, multiple clerks in Cannon's chambers requested transfers. Unusual volume. HR flagged it. Months later, anonymous complaint filed with the Judicial Council alleging hostile work environment and ethical concerns. Then, one staffer decided to do something about it. Someone even said in the cooperation agreement, I couldn't stay silent anymore. What I was seeing wasn't justice. What happened? Someone with access decided enough was enough. Pattern from the transcripts. Staff allegedly pressured to alter docket entries. Clerks allegedly instructed to delay specific attorneys' filings. Law clerks allegedly told to pre-write rulings before hearings concluded. Every time staff complied, except one. The cooperating witness, whoever they are, started documenting in August 2025. For 7 months they recorded, kept notes, met with investigators. Nobody in Chambers knew until Thursday. What changed? The classified documents investigation hit a wall. Investigators needed more than circumstantial evidence. According to sources cited in the filing, the recordings were originally intended to document potential obstruction related to document retention. What they captured was broader, much broader. Months of candid conversations about how she ran her courtroom, how she viewed defendants, how she instructed staff. One senior court administrator told investigators, "When I heard what was on those tapes, I understood why someone felt they had to record." The investigation that started with missing documents became an investigation into the judge herself. See where this is going. If this is making sense so far, like this video. What I'm about to show you is the actual recording that's getting the most attention, the one defense attorneys are calling the confession. Wednesday, 2:34 p.m., courtroom 4B. Here's what happened. Defense attorney Marcus Webb stood up during a sentencing hearing. His client was facing 15 years on drug charges. He played a 47-second audio clip in open court without warning. Cannon's voice, clear as day, recorded in Chambers. 15 years isn't enough for people like him, but that's all the guidelines give me. Room went silent. What followed? Presiding judge immediately called recess. U.S. Marshals cleared the courtroom. Webb was held in contempt, then released 2 hours later. The recording spread across legal Twitter within minutes, 47 seconds. That fast. Now what everyone missed. While media focused on the dramatic courtroom moment, something else happened. A second defense attorney in a completely different case filed an emergency motion in Miami. Same day, same hour, different recording, different case, same pattern. Then a third attorney in Fort Lauderdale. By 6 p.m. Wednesday, 7 different attorneys in 7 different cases had filed motions citing recordings from Cannon's chambers. Coordinated? Absolutely. The DOJ's response, emergency motion to seal all recordings pending review, denied within 3 hours. Federal Judge Patricia Ramirez, assigned to oversee the matter, ruled the recordings were relevant to active criminal cases and defendants had due process rights. Wasn't reactive, calculated. You can see it in the coordination. Defense attorneys across the district had been preparing, waiting. The unsealing order was the trigger. This is where it gets interesting, because if these recordings hold up, if they're admissible, every case can touch becomes questionable. Not just the 31 with active motions, every case going back years, defendants already sentenced, already in prison, already completed probation. If a judge predetermined outcomes, their convictions might not stand. That's not speculation. That's what defense attorneys are arguing. And they have her voice on tape making their case for them. Don't go anywhere. What I show next is what legal experts are saying about admissibility, whether these recordings can actually be used. Drop your prediction below, then keep watching, because the answer isn't as simple as you'd think. What are the experts saying? Former assistant U.S. attorney, 19 years in federal prosecution. If the recordings were made pursuant to a valid federal cooperation agreement, state consent laws may not apply. Plain English, federal authority potentially trumps Florida's two-party consent rule. Another one, criminal defense attorney, 24 years experience with federal appeals. These recordings are a defense attorney's dream. Actual evidence of predetermined outcomes. Key there. It's not inference anymore, it's documentation. Here's what's interesting. Even Jonathan Turley, who often defends judicial independence, admits, if authentic, these recordings present an extraordinarily difficult ethical situation, regardless of how they were obtained. When defenders of judicial autonomy can't defend the content, pay attention. Former DOJ official who served under 3 administrations. The cooperation agreement language matters. If it was properly authorized, the recordings are likely admissible under federal evidence rules. Federal evidence professor at NYU Law School. We're in uncharted territory. Secret recordings of a sitting federal judge. I can't find precedent. That's the problem. There isn't precedent. Consensus from people who actually practice this law. Admissibility will be litigated case by case. Even if excluded from some proceedings, the recordings exist. Cannon's ability to ever return to the bench is functionally over, regardless of legal outcomes. The classified documents investigation just got a significant boost. That's where the professionals land. One more retired federal appeals judge now teaching at Stanford. A judge who believes her statements won't be scrutinized will say things she wouldn't say publicly. That's precisely why secret recordings of judges are so unusual and so devastating when they occur. Think about that. These recordings capture a federal judge speaking candidly, believing no one was listening. 17 hours of her actual thoughts, her actual instructions, her actual approach to cases. Whatever happens legally, that window into her chambers doesn't close. Useful breakdown so far. Hit-like. Seriously, it matters more than you'd think for getting this information out. What comes next is why you should care about this, even if you've never been in a courtroom. Why should you care? Real talk. How this affects actual people. Justice system trust. If you've ever believed courts are fair, pay attention. One federal judge, 847 cases over her tenure. Now all potentially tainted. Here's the math. Average federal case affects the defendant, their family, victims, witnesses. Call it 10 people minimum per case. That's 8,470 people directly impacted in one district by one judge. Your takeaway? The system's credibility depends on judges being impartial. What happens when one isn't? Everyone starts wondering about their judge. Not dramatic, that's human nature. Precedent. This sets a precedent. Several, actually. Next time you're called for jury duty, the judge's instructions matter less if you've seen what judges say privately. Quick example. Say you're a juror. You're told to presume innocence, to wait for evidence, to follow the law, but you've seen transcripts of a judge saying she predetermines outcomes. How seriously do you take instructions from the bench? Now, not trying to be cynical, that's the psychological reality.
If you were there, tell me, did they pierce him in the side that morning? Oh, Lord. Said if you were there, I wonder, did they pierce the Savior in the side? He stopped them at his.
Who's affected right now? 31.
Get up, stand up. Stand up for your right. Get up, stand up. Stand up for your right. Get up, stand up. Stand up for your right. Get up, stand up. Don't give up the fight.
Oh, preacher man, don't tell me heaven is under the earth. I know you don't know what life is really worth. It's not all that glitter is gold. And half the story had never been told. So now you see the light.
Get up, stand up.
Active cases with pending motions, but the real number is larger. According to court records, Cannon presided over approximately
Tell it to girl that you know you got me doing everything crazy that you want me to do. Yes, you have, girl. Don't you
847 cases during her tenure. Criminal defendants, civil litigants, immigration matters. Every defense attorney with a client who lost is now reviewing transcripts. Every person convicted in her courtroom is talking to their lawyer. One federal public defender told reporters, "My phone hasn't stopped ringing." Every client I ever had in her courtroom wants to know their options. Hits immediately. Hits hard. What nobody wants to say. Uncomfortable part. If one judge was doing this, one judge got caught. How many weren't caught? Federal judges serve for life. Limited oversight, enormous power almost never recorded. If you ever believe federal judges were somehow above this, that belief is harder to maintain. Now, not trying to scare you, that's what the record suggests. Practical, what in...
Tell it to. Tell it to, girl, now. You know you got me doing everything crazy that you want me to do.
people are doing. If you have a case in Southern District of Florida, check if Cannon was in...
For homicide detectives, their chance of solving a murder is cut in half if they don't get a lead within the first 48 hours. For homicide detectives, their chance of solving a murder is cut in half.
If you were convicted or sentenced by her, consult a criminal...
For homicide detectives, their chance...
I regret not buying this decor piece sooner.
Appeals attorney immediately. If you're facing federal charges anywhere, ask your attorney about judicial conduct records. Questions to ask a legal professional. Was my case assigned to this judge at any point? What are the grounds for appeal based on judicial misconduct? What's the timeline for filing a motion based on new evidence? Knowledge helps. Here's what one legal aid organization is doing: setting up a hotline specifically for people with Cannon cases. Free consultations, document review. That tells you how seriously the legal community is taking this. 847 cases, thousands of people, one judge's private comments. The ripple effects are just starting. How'd Cannon respond? Made it worse. Honestly, Thursday morning, before the transcripts leaked widely, her attorney released a statement calling the recordings illegally obtained surveillance and demanding their suppression. Quote, "Judge Cannon is the victim of an unprecedented invasion of judicial privacy." Reaction. Legal Twitter immediately noted she didn't deny the statements attributed to her. Judicial privacy started trending with skeptical commentary. By Thursday night, a different approach. Second statement: the transcripts have been selectively edited and taken out of context. Full recordings will vindicate Judge Cannon. Problem: her team hasn't released full recordings, and the transcripts were filed by the Judicial Council, not journalists. The Chief Judge of the 11th Circuit came back. All materials were reviewed in their entirety before any filing. Context was considered. Then Friday happened. Cannon personally appeared at the federal courthouse. First time since her removal last Sunday. She said nothing to reporters, entered through a side entrance. But someone photographed her meeting with her legal team. 5 attorneys, all criminal defense specialists. That image spread everywhere, not cooling down, heating up. Her defenders are still active. Congressional allies are promising oversight hearings. Cable news is divided, but the transcripts are public now. Her own words on the record. Whatever happens next, she can't walk those statements back. What's still unclear? 1. Who's the cooperating witness? Identity remains sealed, but the pool is small. Her chamber staff was never more than 8 people. 2. Are there more recordings? 17 hours is a lot, but the cooperation agreement ran 7 months. Plenty of time for more coming. The Judicial Council has an emergency session scheduled Monday, March 9th, first formal proceeding since recordings surfaced. The Southern District's Executive Committee meets Tuesday, March 10th to discuss case reassignments and appeals process. DOJ Inspector General expected to release expanded findings Wednesday, March 11th. Cannon's legal team has a suppression hearing scheduled Thursday, March 12th. First real test of whether recordings are admissible. Date to watch, Thursday, March 12th. That suppression hearing determines whether these recordings can be used in criminal proceedings against defendants or potentially against Cannon herself. Should know more by then. The wild card. Who else might start talking? If one staffer cooperated for immunity, others might be considering it now. The cooperation agreement offered substantial protections. Second, whistleblower. Third, not confirmed, but legal analysts say it's likely. Right now, we're watching in real time. Subscribe. I'll cover every one of those dates. Monday's emergency session, Thursday's suppression hearing, whatever DOJ releases. When the documents drop, I break them down, notifications on. The story is moving faster than anything I've covered. Where we are right now, 17 hours of recordings from inside Cannon's chambers now public. 31 active cases with pending motions citing the recordings. Cooperating witness identity still sealed. Cannon removed from bench last Sunday, now fighting criminal exposure. DOJ investigation scope reportedly expanding. Legal community mobilizing for potential mass appeals. Scheduled Monday, March 9th, Judicial Council emergency session. Tuesday, March 10th, Southern District Executive Committee meeting. Wednesday, March 11th, DOJ Inspector General expanded findings. Thursday, March 12th, suppression hearing on recording admissibility. Not public yet. Whether criminal referral has been made. Sources say it's under discussion but not confirmed. Whether additional recordings exist beyond the 17 hours already documented, whether other judges in the district are being reviewed based on witness statements, clocks running, the transcripts are out, the words are documented, the legal machinery is moving. Cannon has resources, she has attorneys, she has allies, but she also has 847 pages of transcripts containing her own voice saying things federal judges shouldn't say. That's the situation, that's where we are. Judge Eileen Cannon removed, recorded, exposed, fighting for her freedom. Surface read, a rogue staffer betrayed her trust. But that staffer went to federal investigators, got a formal cooperation agreement, wore a wire for months. That's not betrayal, that's whistleblowing. And what they captured, 17 hours of a federal judge speaking candidly, changes the conversation about judicial accountability. I'll be watching Thursday's suppression hearing. That's the legal moment that determines where this goes. Story's not over, still developing. What happens this week? The emergency session, the DOJ findings, the suppression hearing shapes whether this becomes a criminal case or remains administrative, maybe both. Subscribe for the full picture, not just headlines. When documents drop, I'll break them down same way I did today. Transcript by transcript, filing by filing. No spin, just what the record shows. Whether you think she's guilty or set up, you deserve to see the actual evidence. That's what I do here. Monday's emergency session is 2 days away. I'll have coverage ready. Talk soon.
I'm thrilled today to have with me Senator Jon Ossoff of Georgia. He is here in part because he has a little bit of a different resume than a lot of people in the Senate. His background is in investigative journalism. And you can see that, I think, in the way he works on especially the Committee on Intelligence, although he also sits on appropriations and on rules of administration. He is also, in addition to doing everything he does in the Senate, he is the father of 2 young daughters. So he is a very busy man. And I'm thrilled you took some time out of your day to come talk to us, Senator. Thanks for being here.
Heather, thank you so much. It's an honor.
So let's start, first of all, with how your background in investigative journalism has changed the way, or maybe informed the way that you work in the Senate, especially with regard to corruption and with digging into kind of reining in the executive branch.
Well, Heather, thank you again for having me, and to everybody tuned in across the country. I hope you're having a safe and healthy and peaceful week. Again, I'm Senator Jon Ossoff, honored to represent the state of Georgia in the U.S. Senate. But yes, Heather, before I entered public life, I led a team that produced hard-hitting investigations of official corruption, human rights abuses, war crimes, and organized crime all over the world. And those investigations were aired by international broadcasters all over the world. And it was challenging work, rewarding work, and important work. Because what we did was to unearth truths that powerful people who abuse their power would have preferred remained hidden. We helped brave journalists and brave human rights activists smuggle the truth out of repressive societies with authoritarian states. We informed the public of the reality of how power functioned and how power was abused when those with power believed they weren't being watched or could evade accountability. And I have applied the skills and the approach that I developed doing that work in journalism to my work in the Senate. Of course, since this president was inaugurated, this administration took power, and we've seen the most brazen and overt corruption and abuses of power in American history, but also previously under the Biden administration, when I led long, often bipartisan, hard-hitting investigations of civil rights abuses and corruption in our federal prison system, investigations of the abuse of detainees in Homeland Security detention centers. One facility in Georgia where we exposed that women held in that facility had been subjected to invasive, unnecessary, and sometimes non-consensual gynecological surgical procedures, very difficult truths that the public needed to understand. The abuse of military families and privatized housing on bases. And, Congress has this extraordinary investigative and oversight power, but it's a power that the Congress has allowed to wither and to atrophy. It's a power that Congress needs to use to hold the executive branch and the U.S. government accountable, even when the president is the president from our own party. Now, I believe I was the first and perhaps the only Democratic member of Congress to issue a subpoena to a Biden administration official to compel their testimony on abuses and corruption in the federal prison system. So this is a core role for the Congress, and I have applied my background in journalism to try to be maximally effective at exposing corruption and the abuse of power in Washington.
So what does that look like? There's so many things going on, and I know I get tips all the time from people saying, hey, look into this, look into that. Literally, how do you and your team go about looking into something that you are afraid is an abuse?
Look, it's not altogether dissimilar from the kind of work that has to go into developing and producing really effective journalism, except that we have the power of the United States Senate to apply to get the truth. And before the hearings, if you're doing it well, so much work has gone into preparation and investigation so that when you have those senior officials under oath, and remember, that's one of the key powers of the United States Congress, is that providing information to the Congress, providing false information to the Congress is a crime. So before you even have those officials under oath in front of you, if you're doing it well, you and the investigators on your staff have done that groundwork to unearth the facts in advance of that questioning. Over the last year, investigators on my staff have been looking deeply into the abuse of detainees in Homeland Security facilities across the country. We've identified more than 1,000 credible reports of serious human rights abuses in ICE detention facilities in the last year alone. That's entailed having my investigators go out and do site visits at these detention facilities, interview detainees at these detention centers, cultivate relationships with sources and whistleblowers within the executive branch who can confidentially provide information to the Congress so that we are developing a robust understanding of what's really happening.
So that actually answers a lot of that question, that essentially you look at an issue like detainees, get your staff on board to look into what's happening there, get a series of reports that you then read and are able, because of the power of the Senate, to bring those people into the Senate to ask them specific questions. And crucially, they are under oath. And that's a big difference between a hearing, right, and the kind of testimony that you took on Wednesday.
Yeah, what you saw on Wednesday, this was the Intelligence Committee's annual, what's called Worldwide Threats Hearing, where you have the Director of National Intelligence, Tulsi Gabbard, the Director of the CIA, John Ratcliffe, the heads of NSA, DIA, and FBI. They're under oath testifying about the threats faced by the United States. A lot of attention's been paid to the questions that I asked Director Gabbard at those hearings. I encourage folks to go and search for that exchange. What you saw was that she was tying herself into knots because on the one hand, she was trying to avoid perjuring herself and making a false statement. And on the other hand, she was trying so hard not to publicly contradict the president. And the result of that tension was incoherence. And that's really dangerous when we're talking about intelligence officials whose statutory role, right, that what the law requires them to do is to provide national intelligence to Congress, independent of political considerations. They're there to give us just the facts, unvarnished and objective. Doesn't matter if the boss doesn't like it. But in this administration, they have such a dear leader problem, right? You see these cabinet meetings where it's like something out of North Korea, the sort of, the humiliating way that they praise and lavish extravagant praise on the president. They are so afraid to contradict him in public that they're not providing Congress with clear information about the threats faced by the United States. And that is something that undermines our national security.
So one of the things that really comes through in the questioning that we saw, for example, at that Senate Intelligence Committee event on Wednesday, and that we see through the hearings and the questioning that is increasingly becoming public or being covered by news media, is an attempt of the minority party, the Democrats, who are not in control either of the House or of the Senate, to give Americans a clearer picture of what's actually happening in the country and to slow it down. And I'd love to hear you talk a little bit about how your role as an investigator and as a questioner and as somebody who's compiling a record is not simply window dressing. This is something that the minority party is apparently using to try to stop the juggernaut that has been the Trump administration.
Well, this is a vital role for the opposition. Let me break it down, I think, in a few different ways. First of all, we have to be that force for accountability. When we have these officials under oath in front of Congress and the American people, in order for us to do our jobs well, we have to do all of the preparation to ask the right questions, to expose falsehoods, half-truths, to expose what's really happening in the federal government, right? That is our essential role in the opposition. That's the essential role for the Congress at all times. And if we're going to think about the kinds of structural reforms that are needed to make the United States government and American politics work better, restoring this atrophied muscle that Congress has forgotten how to use of conducting hard-hitting oversight is essential, particularly because corruption in American politics is a problem that goes much deeper than just Donald Trump and the Trump administration. It is the underlying corruption in our political system, especially since Citizens United. I think the most destructive court decision in modern American history that opened the floodgates for secret corporate money, secret billionaire money to corrupt our politics. That underlying corruption that has twisted policymaking against the interests of the American people, that is what gave rise to a demagogue like Trump in the first place. And if we don't solve that problem, even once we are beyond Trump, the country is going to be in trouble.
So that is exactly literally what political historians and political scientists say is the role of the opposition party, is to provide oversight of the executive branch. And one of the reasons that we're so concerned about Congress essentially having given up its role in the three about the three different branches of government to provide that for the American people. But this whole idea of oversight and of returning power to Congress where it belongs in order to oversee the executive, how does that look going forward in terms of legislation, for example, in terms of using this moment to gather information to create future legislation, in terms of bringing accountability to the people in office now? How do you think about going forward?
Look, in the opposition, we've got to use the power that we have to expose the truth and to reduce the harm. But a difficult truth that I think folks also have to embrace and understand is there's no magic button that we're not pushing that would get us out of this nightmare. We are in harm reduction mode. We have to use the power we have in the opposition to reduce harm. We have to make tough, good decisions. Ultimately, though, the only way out of this is not just victory, but landslide victory in these midterm elections. That will empower us to impose a kind of accountability and a kind of transparency that is so desperately needed given who is in power right now. And I really want to caution people against the illusion of powerlessness. The illusion of powerlessness. They want folks to feel like they're just going to do whatever they want, come what may, no matter how much pushback and how much outcry there is. And that's just not true. Even right now, we see them back off when the public outcry is overwhelming. What they just tried to do to veterans a few weeks ago, cutting their benefits. When they froze funding for after-school programs, the public outcry, they backed off. When they froze HBCU scholarships, the public outcry, they backed off. The people have power right now. Don't indulge the illusion of powerlessness. I think some folks have become a little bit addicted to despair, Heather, over the last year. And if we're doom scrolling all the time and fearing all is lost, then we're not taking the action we have an obligation to take at this moment in American history.
Well, I love the idea of the American people having agency to take their government back, and thoroughly appreciate all the work you're doing in the Senate to make that happen. Thank you so much for being here with us, and I hope we do it again soon. Trump is